Hello, I'm Janae Nelson, President and Director Counsel of the Legal Defense Fund. I am delighted to welcome you to our webinar, 1 year later, Equal Opportunity in the Post-Harvard UNC Landscape. We're hosting this event because we know there is considerable interest and concern regarding what corporations and funders can and cannot do in the aftermath of the Supreme Court's devastating decision on affirmative action in 2023. I'm referring to Students for Fair Admissions versus Harvard/UNC, known as the SFFA cases. Some of you have contacted LDF with questions about how the SFFA decision and recent litigation following that decision impact your internal and external operations. Let me say that we are grateful for your interest and engagement regarding this important topic. While LDF has been deeply committed to education equity work since its founding in 1940, the SFFA decision launched a new chapter in this area of our work, which you'll hear more about shortly. Extremist organizations are seeking to rewrite the 14th Amendment. They're seeking to rewrite civil rights laws and some of the most important Supreme Court cases in our nation's history, all with the goal of further entrenching pre-existing racial inequalities and maintaining barriers to opportunity and economic mobility for Black people and other underrepresented groups. If we care about the future of our country, we cannot ignore the persistent reality of racial inequality in the United States. Hardworking Black and Latinx households typically have less than 1/4 of the wealth of white households, meaning we are more financially vulnerable and have fewer opportunities to fully participate in our economy. This is not a product of differing levels of ability or effort, but it is instead a culmination of unequal opportunities and access that have existed for generations. Our increasingly racially diverse society is our greatest strength. The U.S. will be comprised of a people of color majority by as soon as 2024. And people under 18 are already approaching this threshold. As a nation, we cannot afford to forfeit the benefits of the talents and gifts of every student and worker in our country. The Supreme Court's SFFA decision only addressed the use of race as a tip in higher education admissions, and it did not change the law governing employers, businesses, and funders. Existing civil rights laws, like Title VII of the Civil Rights Act of 1964, require employers to remove barriers to opportunity or face liability. We all have an obligation to continue to create workplaces where everyone is valued, everyone is treated with respect and dignity, and where everyone has the opportunity to succeed. And the data are clear. Diverse and inclusive workplaces foster feelings of representation, recognition, and solidarity, and they allow people to bring their full selves to work. Workers seek out employers who have demonstrated their commitment to these shared values. Diverse companies also have higher sales revenue, more customers, greater market share, and greater relative profits. Diversity, equity, inclusion, and accessibility, DEIA, programs based on those principles can also help employers retain talented employees and stay ahead of the competition. Employers, businesses, and funders must continue to invest in programs to ensure that employment and economic opportunity are accessible for all. Fortunately, despite the SFFA cases, the U.S. Constitution and our civil rights laws afford us the tools to address disparities. So I'd like to close with a call to action. We need you to stand with LDF and to stand together as a community as we confront inequality. Opportunity is not a scarce resource to be hoarded. As our country becomes more diverse, ensuring opportunity for all is essential to our multiracial democracy. While talent and potential are found in students and workers of all backgrounds, Opportunities to fulfill that potential are not equally accessible. It is imperative that we support and implement policies to help identify, cultivate, and support all students and workers in having the opportunity to thrive. Ensuring that underrepresented individuals can overcome obstacles to educational opportunity and have a fair shot at good jobs is the right thing to do for our society. DEIA is fundamental to employers' obligations to create workplaces that are free from discrimination. We all want to be included and valued, and we want to be able to bring our talents to the workplace. That only happens when employers invest in opportunities for everyone. We cannot let our country miss out on the contributions of talented individuals because we've closed the doors of opportunity to them. So thank you for taking the time to be here today and for the many ways that you support LDF and its mission, whether that's through your internal work at your place of work to advance racial justice and equality, or by using your platform to take a public position on an issue of racial justice, or through your financial support. We could not do this work without you. So now I'd like to turn the webinar over to Jinhee Lee, Director of Strategic Initiatives, who will provide an overview of the post-SFFA legal landscape and set the stage for today's speakers. Thank you again.
Thank you, Janae, and thank you to everyone for joining us today. My name is Jinhee Lee, and I'm Director of the Strategic Initiatives Department, which houses specific projects and campaigns that integrate LDF's multifaceted advocacy tools, which include litigation, policy, organizing, communications, research, and public education to maximize the impact of affirmative, strategic, and community-centered advocacy that secures the full citizenship and equality of Black Americans. As part of this integrated advocacy, LDF launched the Equal Protection Initiative, which is housed within the Strategic Initiatives Department to address the aftermath of the Supreme Court's affirmative action decision with a holistic and interdisciplinary approach. I'm excited for this opportunity to share what LDF is doing to protect and advance public and private sector efforts to remove barriers to equal opportunity in employment following the Supreme Court's affirmative action decision last term. LDF has been a long-standing stalwart advocate for educational equity, including the litigation that led to the decision in Brown v. Board of Education, which ended legal racial apartheid in the United States. LDF has also been involved in every affirmative action case that has come before the Supreme Court. As part of this advocacy, LDF represented 25 Harvard student and alumni organizations as amicus curiae, also known as a friend of the court, from the trial court all the way to the United States Supreme Court. LDF also submitted an amicus brief on behalf of itself and the national NAACP to explain to the Supreme Court the proper meaning of the Brown decision, which has been distorted by opponents of affirmative action. In addition, LDF led an amicus strategy that resulted in an unprecedented 82 corporations signing on to one of 3 corporate amicus briefs in support of affirmative action. In all corners of our country, systemic racism has prevented too many talented and hardworking people of color from accessing equal opportunities. This is especially true for Black people in the United States, who have faced the most egregious forms of racism throughout American history. Since the Supreme Court's decision last year in Students for Fair Admissions versus Harvard and the University of North Carolina at Chapel Hill, also known as SFFA, opponents of civil rights have sought to misuse and expand that decision to challenge racial equity programs outside of higher education, such as in K-12 education, government contracting programs, and private employment. These attacks are part of a long-term strategy to distort equal protection and anti-discrimination law and dismantle the tools we've relied on for decades to ensure equal access to educational and economic opportunities for people of color, women, LGBTQ plus individuals, and other protected groups. In light of these challenges, many organizations are wondering whether they can continue to invest in recruiting, mentoring, and other programs that help break down barriers to opportunity in the workplace, in grant making, and in other areas. The stakes for our country are high. If opponents of civil rights succeed in dismantling the core civil rights protections that have helped us move toward racial equality over the last several decades, or even worse, if organizations voluntarily end lawful programs, then we risk losing out on a generation of talented and skilled individuals with disastrous effects on our economy and our multiracial democracy. Before we dive in, it's important to remember what the Supreme Court's affirmative action decision did and did not do. The Supreme Court in that case held that Harvard and UNC's limited consideration of race in its higher education admissions process violated the Equal Protection Clause. The court also held that the admissions process violated Title VI of the Civil Rights Act of 1964, which lays out the anti-discrimination obligations of organizations that receive federal funds. The court did not decide anything regarding employment, supplier diversity, grant making, or funding, which are typically governed by a different set of laws. At LDF, we are working to create a multiracial democracy where dignity is sacred, power is shared, and thriving is the standard. We hope this webinar provides you with useful information to help you continue to do just that. I am pleased to be joined today by my colleagues at LDF, many of whom have worked on the SFFA case since it was before the trial court. I myself represented the Harvard student and alumni organizations from the very beginning and argued on their behalf before the First Circuit Court of Appeals. I will first turn it over to Michelle Turnage-Young, Senior Counsel and Co-Manager of LDF's Equal Protection Initiative. Michelle was also on the legal team representing the Harvard student and alumni organizations since 2017. Michelle will be followed by Amalia Smirniotopoulos, Senior Policy Counsel and the other co-manager of LDF's Equal Protection Initiative. Both Michelle and Amalia will provide a closer overview of the post-SFFA landscape. We will then hear from Jenny Holmes, Deputy Director of Litigation. Jenny was also on the SFFA legal team, presenting witnesses at trial and also providing closing arguments on behalf of our clients, the Harvard student and alumni organizations. Jenny will discuss the next frontier of cases after the SFFA decision. Last, but certainly not least, will be Keisha Moore, who is the Manager of Research at LDF's Thurgood Marshall Institute. Keisha will discuss the current social science research literature about the best ways to remove unfair barriers to opportunity in order to create a diverse team of talented students and workers. She will also offer guidance to companies and funders based on this research. As a reminder, please add your questions to the comments box on your screen. We want to hear from you and know what it is that you want to learn about this decision and the post-SFFA landscape. I will now hand it over to my colleague, Michelle Turnage-Young.
Thank you for that helpful overview, Jen. My name is Michelle Turnage-Young. I am Senior Counsel and Co-Manager of the Equal Protection Initiative at LDF. Now we'd like to talk about some recent cases that we think illustrate how courts are dealing with the legal challenges brought by opponents of civil rights. Although 42% of women who opened new businesses between 2014 and 2019 in the United States were Black women entrepreneurs receive less than 1% of venture capital funding nationwide. The Fearless Fund tried to address this disparity by running a grant contest intended to benefit businesses owned by Black women entrepreneurs. The American Alliance for Equal Rights sued the Fearless Fund, alleging that its members, who are not Black women, are harmed because they cannot compete for the $20,000 prize in the Fearless Strivers Grant Contest because of their race in violation of Section 1 of the Civil Rights Act of 1866, which has been codified as 42 U.S.C. Section 1981. Section 1981 prohibits racial discrimination in the making and enforcement of contracts. On June 3, 2024, a panel of the 11th Circuit issued a preliminary injunction barring the Fearless Fund from proceeding with the contest. Before you can march into court, you have to show something that's called standing to sue. To do this, you have to show that you were harmed, that it was the defendant who harmed you, and the relief you are asking for will remedy that harm. So in the Fearless Fund case, the 11th Circuit first held that AAER has organizational standing to sue on behalf of anonymous members it identified by pseudonyms on the basis of their allegations that they owned businesses, would put the grant funds to specific use, and could not participate in the grant contest because they are not Black women. Second, the court concluded that the Fearless Fund's grant competition is a contract. So Section 1981, which prohibits racial discrimination in contracting, applies. The original grant competition language said that if you apply, you agree that this is a contract. So even though the Fearless Fund later changed that language, the 11th Circuit reasoned that it still had an indemnification provision and an arbitration provision and was thus a contract. Third, the 11th Circuit held that the Fearless Strivers Grant Program did not constitute a lawful remedial program because limiting the contest to Black women served as an absolute bar to the advancement of non-Black business owners. Fourth, the court rejected the argument that the First Amendment permits the act of excluding a group based on a protected category as a means of expression. The 11th Circuit reasoned that the Supreme Court does not recognize and, in fact, expressly disclaims a right to refuse to serve members of a protected class. It's important to note that this opinion is not the final decision in the case, but rather it's only about whether the Fearless Fund can proceed with the contest while the district court continues to consider the legal issues in the case. It's also binding only in the 3 states in the 11th Circuit, namely Alabama, Georgia, and Florida. There are a couple of key takeaways here. First, the 11th Circuit did not say that all remedial programs designed to remedy discrimination are unlawful. The court assumed without deciding that these programs were permissible. They just found that the Fearless Fund's program did not fit the bill. Second, the Fearless Fund decision addresses only selection processes that can be construed as a contract, where race determines eligibility. It does not prevent the use of other tools designed to remedy the severe and persisting discrimination that continues to limit opportunities for Black people. For example, funders can still try to solicit additional grant applications from Black-owned companies or organizations, or can ask applicants to describe the barriers they have experienced in accessing funding. The decision also does not bar funders from giving to organizations that support particular groups, provided that the selection process does not completely bar non-Black people and there is a valid remedial program. Finally, and most importantly, many other legal challenges to programs that seek to advance racial equality have failed. Let's talk a little bit about when courts have found that organizations actually have the ability to sue. So the Second Circuit recently affirmed the dismissal of a similar lawsuit for lack of standing. In 2022, an organization named Do No Harm sued Pfizer over a fellowship program that sought to increase the pipeline of Black, Latinx, and Native Americans at Pfizer. Unlike the 11th Circuit, the Second Circuit concluded that Supreme Court precedent required Do No Harm to name an injured member to establish standing. Because Do No Harm's affected members were proceeding anonymously using pseudonyms, the Second Circuit affirmed the district court's dismissal of the lawsuit. Courts also recently dismissed similar challenges against Hello Alice for a grant program to support Black-owned businesses and the Latinx-led community development financial institution Lift Fund Incorporated and Bexar County's Small Business Assistance Program, which provided grants funded by American Rescue Plan Act dollars to local small businesses. The Supreme Court itself had more to say about standing in its recent opinion in FDA versus Alliance for Hippocratic Medicine, the case challenging the FDA's approval of mifepristone, which is half of a 2-drug protocol to abort early-stage pregnancies. In a unanimous opinion, the Supreme Court held that AHM did not have standing to sue, writing, quote, "An organization that has not suffered a concrete injury caused by a defendant's action cannot spend its way into standing simply by expending money to gather information and advocate against the defendant's action," end quote. The Supreme Court's opinion in the mifepristone case may make it even more difficult for the various Edward Blum-led organizations to establish standing. Let's talk a little bit about what's happening in the cases involving schools. So earlier this year, the Supreme Court declined to hear Coalition for TJ versus Fairfax County School Board and Students for Fair Admissions versus the U.S. Military Academy at West Point, leaving in place lower court decisions that upheld these programs. As of the date of this recording, there is also a petition for the Supreme Court to hear a lawsuit involving the Boston exam schools. The Supreme Court's decision not to hear the TJ case leaves in place the Fourth Circuit's ruling that race-neutral admissions policy changes that helped remedy the under-identification of Black, Latinx, and low-income Asian American students for admission to a selected public high school were constitutional. The Supreme Court's decision in the TJ case suggests that schools, businesses, and other entities are free to explore race-neutral methods of ensuring equal opportunity for all. However, as of the date of this recording, as I mentioned, there is a cert petition pending in a similar case involving the Boston exam schools. Now, SFFA sued West Point and the U.S. Naval Academy after the Supreme Court announced in SFFA versus Harvard that its opinion did not address the consideration of race in admissions at service academies, given that those institutions may have distinct interests. The district courts in both those cases denied SFFA's request for preliminary injunctions, barring those schools from considering race in admissions while the lawsuits are pending. In the West Point case, SFFA also asked the Second Circuit and the Supreme Court for an emergency injunction, but those courts declined to grant that emergency injunction. That the Supreme Court declined to grant the requested emergency injunction suggests that, under the right factual circumstances, even race-conscious measures for advancing equal opportunity may be legally viable. And certainly, the Supreme Court was clear in its opinion in SFFA versus Harvard that when it comes to race-based measures, there is a compelling government interest in, quote, remediating specific, identified instances of past discrimination that violated the Constitution or a statute. And now I'd like to introduce my colleague, Amalia Spirniotopoulos.
Hi, good afternoon, everyone. As Michelle said, my name is Amalia Spirniotopoulos. I'm a senior policy counsel at LDF and co-manage our Equal Protection Initiative with her. I'm going to talk to you now about some recent cases that gave further clarity to the amount of harm a plaintiff would have to show to actually bring a claim against an employer for a DEIA program. So in Muldrow versus St. Louis, the plaintiff, Jatanya Muldrow, alleged that her employer violated Title VII when it transferred her to another position against her will because her supervisor wanted to hire a man instead of her. The Eighth Circuit dismissed her case because it believed Title VII did not protect her because she did not experience, quote, a materially significant disadvantage, a standard which was not required by several other federal courts. In April, the Supreme Court unanimously held that an employee challenging a job transfer under Title VII must show that the transfer brought about some harm with respect to an identifiable term or condition of employment, but that harm need not be significant to violate Title VII's anti-discrimination provisions. Some commentators have argued that a ruling for Muldrow would threaten DEIA practices. However, even before the Muldrow decision, it did not appear that Title VII lawsuits challenging DEIA programs were viable in those circuits that were not using the material adverse disadvantage standard. So it does not follow that those programs should now be actionable in the wake of that case. Further, DEIA programs generally do not create differential treatment based on race or gender, and accordingly, concerns that Muldrow may detrimentally impact DEIA initiatives are overblown. So next, I want to talk to you a little bit about some of the cases involving federal contracting. The Minority Business Development Agency was first established by Richard Nixon and was recently codified back in 2021. The agency offers technical assistance to help small businesses. And until recently, its programs were targeted at those business owners who needed the most assistance. In particular, people from particular racial and ethnic groups who were presumed to have experienced discrimination. Unfortunately, earlier this year, Judge Pittman in the Northern District of Texas held that the Minority Business Development Agency's use of this presumption violated the U.S. Constitution. Importantly, Judge Pittman did hold that the federal government had a compelling interest in remedying discrimination in prime contracting that could justify targeting the MBDA's program to particular racial groups, but ultimately found that the agency's use of that presumption was not narrowly tailored enough to serve that interest. Judge Pittman then issued an order permanently enjoining the agency from imposing any racial or ethnic classifications or otherwise using an applicant's race or ethnicity in determining whether they can receive assistance from the agency's business centers, and declared those classifications unconstitutional. We are still waiting to see if either side will appeal that decision as of the time of this recording. So finally, to wrap up our case overview, I want to talk to you about a case, Young versus Colorado Department of Corrections. In this case, a white male corrections officer objected to taking an anti-bias training, which included concepts such as fakeity and white fragility, alleging that these concepts could create stereotypes about white people. He initially complained within the Department of Corrections, but the state did not investigate his complaint, and he resigned shortly thereafter. The 10th Circuit held in this case that the state of Colorado did not violate Title VII of the Civil Rights Act of 1964, which prohibits discrimination in employment, ultimately finding that the training itself was not sufficient to alter the terms and conditions of employment. The training occurred only once. There were no subsequent discriminatory acts as a result of the training. Mr. Young did not experience any harassment. There were no derogatory remarks or other issues that would actually provide enough basis to find that he had experienced harassment in his workplace. I'd also like to note that in a similar case, Favre v. Honeywell, the Equal Employment Opportunity Commission itself filed a friend of the court brief stating that unconscious bias trainings, like those at issue in Young, are not inherently discriminatory, and that it was not retaliation to fire an employee for refusing to take such a training. As we sort of wrap up our case summary, it's important to remember that cases like these, alleging discrimination against white people, are outliers. The reality is that Black people continue to work in lower paying jobs and industries compared to white people with the same level of education. They continue to face discrimination in small business lending and other financial services that limit their ability to start a company and compete with other businesses. And the vast majority of cases alleging discrimination in employment seek to address those very real barriers to opportunity. In the last few months alone, the U.S. Equal Opportunity Commission has brought suits against Tesla, Sheetz, General Mills, and numerous other companies for employment discrimination. In light of this reality, pulling back from programs designed to ensure equal opportunity carries its own risks. To sum up, there are a couple of key takeaways from these cases. First, as in Do No Harm versus Pfizer and other cases, several challenges have failed at early stages because plaintiffs have struggled to show harm. Second, the outcome in the TJ case reaffirms that programs that do not consider race remain lawful, and this includes many DEIA programs. Third, while the decisions in Newsyard and the Fearless Fund did not disturb the fundamental premise that programs can still consider race in decision-making in order to remedy specific instances of past discrimination. Those cases merely held that those specific programs did not comply with the legal standard needed to actually have a valid program. While several of the decisions we have talked about today are disappointing, They have limited impact on the state of the law nationwide. None of these decisions bind all of the courts in the country. Many are at the district court level. What that means as a practical matter is that other judges, even other judges in the same district court, are not required to follow them, though they may choose to follow their reasoning if they find it to be persuasive. By contrast, the decision in the Fearless Fund is a circuit court decision, as is the decision in Young versus Department of Corrections in Colorado. What that means is that other courts in that same circuit, in the 11th Circuit, Alabama, Florida, and Georgia, for example, have to follow the reasoning in that case, but other courts in other states do not. And opponents of civil rights will have to bring new cases to get those courts to adopt that reasoning. Next, I'm pleased to introduce Jennifer Holmes, Deputy Director of Litigation at LDF.
Good afternoon. I'm Jennifer Holmes, Deputy Director of Litigation. I'm going to discuss what could be the next frontier of cases in this area. And those are legal challenges that take aim not only at programs that strive to expand opportunities and pipelines for underrepresented groups, whether through race-conscious or race-neutral means, but also at requirements to simply collect, report, or disclose demographic information altogether. And this is concerning because it plays into the idea that merely acknowledging race, collecting information about race, and studying race is itself discrimination. And if successful, these legal challenges could eliminate important sources of information that are crucial for rooting out discrimination, for tracking trends, for identifying policies that work or don't work to expand opportunity. And without this data, it's more difficult to hold companies accountable. There are countless government requirements to collect and report race and other demographic characteristics, from EEOC regulations to the Department of Education's Office of Civil Rights collecting and publishing information about every public school in the country, to the census. And all of these could be in jeopardy if cases like these gain traction. The good news here, however, is that there is a robust body of case law that defends and protects the ability of governments to require demographic disclosures. So while that is helpful, we should still be clear-eyed about that these attacks are on the horizon. So I'll quickly give two examples. First is the NASDAQ diversity rule case, and this is the Alliance for Fair Board Recruiting versus SEC. So in 2020, NASDAQ adopted a rule for companies that list on its exchange, and it had two components. First, it required companies to disclose the race, gender, and LGBTQ+ makeup of their board of directors. And second, it set diversity objectives that companies should strive to have at least 2 diverse directors on their board, including 1 woman and 1 person of color or LGBTQ+ identifying person. And if not, then they should provide an explanation about why they did not meet these diversity objectives. And that explanation could contain anything. It's essentially a voluntary component of the rule. NASDAQ had multiple reasons for adopting this rule. Many investors had asked for diversity information about corporate boards in order to make better investment decisions. And part of the reason is because there's a body of empirical evidence that has shown that corporate boards with greater race and gender diversity are linked to better performance. But despite this link, boards have been very slow to diversify, largely because candidates are normally recruited from the networks of existing directors, which are largely white and homogenous. And even the small gains in diversity that we've seen since 2020 have started to regress. So the SEC approved NASDAQ's rule in 2021, and it was challenged shortly after by 2 organizations, including AFBR, which was one founded by Ed Bloom. And their claims fall into 2 buckets. First, challenging the SEC's rulemaking process and their statutory authority, and second, bringing constitutional challenges under the First and Fifth Amendment. And there they argued that the rules were violated free speech because they compelled companies to speak, and that the rules violated equal protection because they encouraged companies to make race-based director selection decisions. The case was in the Fifth Circuit, and a 3-judge panel upheld the rule. However, the petitioners sought rehearing en banc, which means now the full complement of judges on the Fifth Circuit will consider the case. And so LDF decided to get involved and file an amicus brief. We felt that it was important to submit a brief that was a full-throated defense on equal protection grounds of why this rule is valid. And the parties in this case were not that focused on the equal protection argument. So we felt that this case implicated an important civil rights doctrine, and we should make the argument. We also recognize that this is one of the cases that's kind of going into the next frontier. It's not just an attack on a race-conscious program, but also an attack on just the requirement to disclose information about diversity or demographics. So a section of our brief was dedicated to demonstrating that the collection and reporting of demographic data does not trigger heightened constitutional scrutiny and ultimately does not violate equal protection. We pointed to plenty of cases showing that collecting data on race and gender, like in the census or public school information or EEO regulations, have been upheld by many courts. And courts have also recognized that this sort of information is an essential tool in uncovering illegal discrimination, which undermines the argument that the petitioners were making here, that the disclosures themselves are discriminatory. So we await a ruling. We're not naive about the fact that the Fifth Circuit has been very hostile to DEI type programs, but we do hope, even in the event if this rule is struck down, that it's done on narrow grounds and does not upend equal protection doctrine. So moving on to the next case, and this is the National Religious Broadcasters versus the FCC. In February 2024, the FCC reinstated a rule that required television and radio broadcasters to submit annual reports on the racial, ethnic, and gender breakdown of their workforce, and those reports would also be made public. This rule had actually been in place for many years, from 1970 to 2001, but it was suspended after there were lawsuits challenging the rule, although those lawsuits were not aimed squarely at the disclosure part of this rule, but other elements that the FEC had placed upon stations to recruit or diversify their workforces. And none of those cases actually held that just the collection and disclosure of the data was itself invalid. So after reinstating the rule, the rule was challenged by multiple organizations: the National Religious Broadcasters, the American Family Association, and the Texas Broadcasters Association. And they've brought similar claims to the NASDAQ case. They claim that the FCC exceeded its statutory authority, but also that this rule violates equal protection under the First Amendment and violates free speech under violates equal protection under the Fifth Amendment and violates free speech under the First Amendment. According to their claims, they argue that the FCC is trying to pressure stations to engage in race-conscious hiring by making this information public and relying on what they call private activists to pressure the station into diversifying their ranks. So this will be a case to watch, because here we have a rule that does not have any race-conscious elements. It's not specifically about expanding opportunities or DEI. It's simply about collecting data, and it still has been challenged by these group of people that have been opponents of civil rights. So we're keeping a close eye on this as well.
Thank you, Jenny. We should not underestimate the challenges we are facing. But as a nation, we cannot afford to forfeit the benefits of the talents and gifts of every student and worker in our country. By 2043, the majority of people in the United States will be people of color, and people under 18 are already approaching this threshold. Almost 1 in 4 people under the age of 30 identify as LGBTQ+, and our electorate will soon contain more people in that age group than any other. Opponents of civil rights cannot turn back the clock on these demographic shifts. These are the workers, customers, and leaders of today and tomorrow. Ensuring equal opportunity for all is thus essential to our multiracial democracy. Diversity brings many benefits, including increased innovation and profitability. More importantly, however, It is a sign that an organization is fulfilling its obligations not to discriminate. Programs that create diversity, equity, and inclusion are fundamental to employers' obligations to create workplaces that are free from discrimination. We all want to be included and valued, and we want to be able to bring our full selves and talents to work. That only happens when employers invest in opportunities for everyone. By contrast, our opponents want to make our workplaces, schools, and other sectors segregated, unfair, exclusionary, and inaccessible. We can't let that happen. Support for programs that increase diversity, equity, inclusion, and accessibility remains strong. Indeed, 78% of U.S. adults support businesses taking active steps to make sure companies reflect the diversity of the American population. 72% of C-suite and human resources leaders in corporate America plan to increase their commitment to DEI within the next 2 years, while only 4% plan to cut back or eliminate their programs. Business leaders, EEOC commissioners, federal agencies, and many members of Congress support DEIA. In response to attempts by opponents of civil rights to turn civil rights laws on their head, LDF has been fighting back. In January, we released our guidance for businesses, funders, and corporations, and have trained hundreds of employment lawyers, DEIA professionals, C-suite executives, and other stakeholders on what they can do to advance equity. We have been working with Congress to build a robust legislative record to support remedial federal contracting programs, including working with the Senate Small Business Committee at a hearing in May. This evidence will be used to attempt to restore the ability of the Minority Business Development Agency and other federal agencies to provide targeted assistance to address discrimination against Black businesses. We have also been working with Congress to preserve funding for DEIA and to explore possible legislative solutions to the legal challenges we are seeing. And we have also partnered with Asian Americans Advancing Justice, AAJC, the National Women's Law Center, Latino Justice PearlDeaf, and the National Center for Lesbian Rights to form an intersectional multiracial coalition called the Advancing Racial Equity Alliance to develop shared strategies. In addition, LDF's Thurgood Marshall Institute, also known as TMI, has been researching what kinds of programs are most effective at actually addressing past discrimination and achieving the goals of diversity, equity, inclusion, and accessibility. So now I'm going to turn it over to my colleague, Keisha Moore, Manager of Research at TMI, to talk more about her recent work.
Thank you, Michelle. Good afternoon. I am Keisha Moore, Manager of Research at TMI. I'm excited to be a part of this important conversation. I will begin by sharing briefly about what the social science research literature teaches are the best ways to remove unfair barriers and to promote diverse team of talented students and workers. And then I'll pivot to share guidance for companies, businesses, and funding based on the results of the empirical research. According to the social science research literature, the most promising DEI interventions that resulted in improved representation of Black workers within higher occupational positions are a full-time DEI staff, a DEI task force, mentoring programs, and targeted recruitment programs. In an analysis of more than 800 corporations over 30 years, researchers found that the appointment of a full-time diversity staff position on average led to a 10% increase in the proportion of white women in management and a 15% increase in the proportions of both Black men and Black women within a 5 to 7 year time span. An analysis of the 2002 literature survey data shows that following the establishment of diversity task forces, companies saw significant increases in white women and in Black, Hispanic, Asian men and women in managerial positions. Mentoring programs also show positive effects on Black women and Hispanic and Asian men and women in management. Research shows that cross-race mentoring, usually when the mentor is a white male and the mentee is a person of color, is both challenging and necessary. Active women and minority recruitment and special promotion programs are also associated with increased diversity. And a study analyzing data from the multi-city study of urban inequality found that companies that make special efforts to recruit women and minorities are more likely to hire them. So unfortunately, companies' willingness to actively challenge the exclusionary and unfair practices that exist within the workforce have been more reactionary and less the product of a true commitment to fairness. Increased hiring of Black managers in specific and DEI in general, it's largely been dependent upon public support, such as the pro-racial justice protest of 2020. In 1989, the study of Black managers and corporations in Chicago found that their increased employment was disproportionately focused on positions responsive to the Black community's demand for civil rights. Thus, they occupied, quote, a highly visible but economically vulnerable Black managerial elite. Although DEI-related jobs increased by 55% after the public protests associated with the murder of George Floyd, DEI positions declined at a higher rate than non-DEI positions. And you can see in the figure on the screen, DEI positions declined at 33% and non-DEI positions at 21%. Over 300 DEI professionals have left companies that have experienced recent layoffs and sometimes amounting to the exodus of entire diversity teams. Now is the time to observe which organizations' commitment to expanding equal opportunities for all was authentic and which ones were more symbolic. Workplaces function best when they benefit from the talent of all aspects of society and create an environment where employees individually and collectively produce their best work. The following are the best practices in cultivating this type of workforce. 1, integrate the work of diversity, equity, inclusion, and accessibility throughout the entire organization, not simply the responsibility of one department or one staff member. Companies with organization-wide processes show more compliance and greater results from their DEIA efforts. 2, show strong commitment from organizational leadership to the principles and goals of DEI. Leadership matters. 3, use DEI audits to create a targeted plan to address the organization's DEI issues for a more impactful outcome. The knowledge uncovered can be used to create DEI goals, design a plan, determine metrics for tracking and measuring success, and promote accountability for organizational DEI commitments. 4, integrate multiple types of identities into diversity training sessions. Diversity trainings can be an important tool of ensuring anti-discrimination in the workforce and promoting a positive work culture. However, research suggests that such trainings work best when part of a broader DEIA initiative, when they are actively supported by leadership, when they are voluntary, and when the examples in the training highlight intersectional identities. 5, provide supportive resources, including funds and disaggregated data to support DEIA efforts. And 6, cultivate a proactive, internally driven approach so that the commitment is institutionalized and not a, quote, fad.
This concludes our webinar. Thank you for joining us today and for supporting the Legal Defense Fund. For the latest news, please follow us on social media.